Hey everybody, welcome back to Girl Talk. Thank you so much for joining me. As always, before we get started, if you could give me a like, share, thumbs up, comment, all that other good stuff, I would appreciate it. So before we get started, we are actually going to go over Laura Owens Parents Chapter 11 Bankruptcy. So I don't think we're going to get to the grand finale today, but it will give you a little idea of how this started and probably how it's going to end. And like I said before, even if you're not into trials and everything, you have to listen to this attorney. I mean, she is just like, honestly, you need to get your paper bags ready because you're going to be hyperventilating. Seriously. But before we get into that, and I should have done this at the beginning of the month, and I wasn't even thinking. And we kind of have to talk about a very serious subject right now. It is Sarcoma Awareness Month, and I don't know a lot about it. I do know that it can happen in any part of your body, and I believe it starts out with a lump. And it is a type of rare cancer that it's kind of one of those things we don't know a lot about. And my friend, dear friend, good friend of mine, um, is battling. And while she's in the battle, she is winning the war. So we just want to keep her in our prayers and our thoughts. And hopefully, we get some good results and things like that. Actually would like a little bit later, once I do get more information and education, um, actually would like to kind of do a stream on sarcoma, just to kind of get awareness and education out there. It's not something I know a lot about, um, but I'm willing to learn. And I think that it's important to talk about, it's important to know, and it's important to know what symptoms and signs that we should look out for. So that will be coming up in the next few weeks. But if you could, send some positive vibes, some good light, prayers, whatever you believe in, and it is so much appreciated. So I wanted to bear with me here. So yesterday I did a thing. Actually, I did a thing the day before yesterday, but I had to get a new phone. And I've had my own old phone forever. And I'm one of those people that I don't care if there's, a brand new phone out there. I'm keeping my phone until it takes a shit, right? And my phone was about, I don't know, 6 years old. And it wouldn't keep the charge. And then it wouldn't update. I'm like, do I really want to get a new one? Well, as I told you before, I work for a technology company. Technology has changed because I was ready to bounce my head off a freaking wall and throw the phone out the window yesterday. So we'll see how it goes today. And plus, I wanted to kind of check out the sound. So what we're going to do is we're going to use the sound from my phone, and hopefully we'll see how it goes. Um, say a prayer, guys. So here we go. This is with the first one. And this is going to be, this one isn't so long. This is going to be about 12 minutes long, with me chiming in there. So here we go.
Naylor and Ronald Owens. I'll take the appearances in the Naylor and Owens matter.
Good morning, Your Honor. I'm Elizabeth Ann Naylor, appearing pro se, and my husband and co-debtor, Ronald Stephen Owens, is also present with me today representing himself.
All right, thank you for your appearance, ma'am.
Good morning,
Your Honor, Jennifer Giaimo on behalf of the United States Trustee, and thank you for allowing me to appear by Zoom because I am out of town this week.
All right, thank you.
Okay, quick pause. So, Jennifer Giaimo, I think I said that right. That is who is Queen Jennifer. That is the attorney that will have your nails biting, crawled up in a corner, in a fetal position, and probably crying. Here we go.
Thank you. Good morning. Any other appearances? No. All right. We've just called the Naylor and Owens matter. Counsel, if you'd like to make an appearance in that matter. Okay. All right. Let's go ahead and proceed. All right. So, Ms. Naylor and Mr. Owens, this is your emergency motion to extend the automatic stay in this case. As you are aware from preparing the papers, the automatic stay will expire shortly unless the court finds that grounds exist to find and conclude that you have met your burden of establishing clear and convincing evidence to enable this case to move forward. I did want to clarify a couple of things for you, Ms. Naylor and Mr. Owens. Just some of the statements you made were that U.S. trustee hadn't proven bad faith, but that's not really their burden. It's your burden to prove that this case was filed in good faith, and you have to have clear and convincing evidence. One other thing I also wanted to advise you is that the court's mortgage modification program is not mandatory. It is a program that can be administered through this court. The creditor, however, is not compelled to participate. When they do participate, of course, there's a requirement to appear and to participate in good faith. But the process is that you request to be in the program, and the creditor can ask to be removed from the program. So I did want to clarify for you that that is not something that the court can require the creditor on your home to participate. Okay. Did you have a question about that? No. Okay. All right. So this is your emergency motion to extend the automatic stay. The primary thing that the court is looking at is what has changed between when your first case was dismissed and the filing of your new case. That's really all I'm concerned with. What is your change of circumstances, and what can you tell me to show that this case can move forward successfully? So you've told me a lot of information about your dealings with the creditor.
Okay, I'm going to interrupt real quick. So let's not forget that they had filed Chapter 13. And they didn't disclose a lot of information. So we want to keep that in mind. And so when the judge said, what has changed, that we're going from a Chapter 13 that was dismissed to now a Chapter 11, like, okay, what's going on here? So that's what she was talking about. Right now we are listening to the Chapter 11.
About you've indicated that your income is steady, but I can't tell that has been a change from your prior case and when it was dismissed. So why don't you focus on that information? Well, the prior 13 was dismissed not because we abandoned it, but because our attorney didn't act when I asked him to in writing. Well, let me just stop and interrupt you there, because I've reviewed the papers filed in the prior case, and the reason your case was dismissed is because you did not turn over to the trustee tax returns, and because your plan payments were delinquent. And I believe, and also you had outstanding objections to confirmation that were unresolved. So whatever may have happened with your attorney, that I don't know what happened there, but filing your taxes and turning over your returns and paying your plan payments are all within
your control.
Correct. And as far as the tax filing is concerned, we have had major health issues with my husband I'm his primary caretaker. And I had not filed the taxes because I knew we didn't owe anything at that point, and I had other issues that I was taking care of. And then when we filed for bankruptcy and I wanted to get the taxes filed, I was unaware that when you file for bankruptcy, the credit card companies make it so that you no longer have access online to the prior credit card information. So I didn't.
Why is the credit card information something you're telling me about?
For the purposes of deductions and expenses, I had relied on those being available online. So we have since filed the returns for 23 and 24 that were asked for, and so those have been taken care of. As far as the plan payment is concerned, we had some major unexpected expenses that could not be put off. We had major storm damage and cleanup that had been required, and we had septic tank issues, and we had car repair issues, and the money had to go into those things from an emergency crisis standpoint. Going forward, we would anticipate that the amount of income that we have that is guaranteed, the $21,000 a month income that is guaranteed under our Social Security and pension benefits, would be enough to give us the restart that we need here. And also, as far as the payments are concerned, in dealing with SPS, they would send me information that indicated that the entire amount of arrears had to be paid at a time, that it wasn't like you can just make a one monthly payment, that the whole thing needed to be paid. So it seemed like until we could actually talk to SPS and get things clarified with SPS, it didn't seem to make sense to throw money there when they would have the home in foreclosure anyhow.
So let me go back to my question for you, which is, what has changed in your personal and financial situation since the dismissal of the first case and the filing of the second case? Because the guaranteed income you just mentioned, the $21,000, that was in fact part of the first case. So that's not a change. So what has changed?
Correct. So we also had some expenses with two of the LLCs that we have that are no longer applicable, and so that is a big burden that is off the table.
Could you be more specific?
We had.
So I just want to chime in here. These LLCs are going to become very important.
One LLC that had that was an investment in a short-term rental that we had to forfeit. We had expenses, major expenses with that, and we had bookings that were down from that. We also had.
So wait a minute before you move on. I guess I don't understand. Your papers didn't tell me anything about whatever it is you were just mentioning. Bookings with rental property.
Liz Max Investments. I believe it was listed as zero value in that.
Well, I mean, your motion to extend the stay didn't describe a change of circumstances involving what you've just mentioned. So are you saying that you had some real property that you have surrendered in the interim period?
Yes. So it was an investment that was costing us money, and as I say, it's listed as Liz Max Investments on there.
Okay, so one of the struggles that I'm having in preparing for this hearing, and let me roll back for a moment and just say that the papers you filed are not acceptable in terms of being too lengthy. You cannot file 29-page responses. We have rules about how long papers can be. In some courts, the court will literally take the filing you have filed, find the page limit, rip it off and throw it away. I did not do that. I read your papers, but in the future I'm not going to. So your motion and your reply were both too lengthy. But the problem is I don't have schedules and statements in this case. You've received an extension of time to file those, which was good. I'm glad that you got court authorization to file those papers later. The problem is that they're due at a date that beyond this hearing. So as I'm preparing for your hearing today and reviewing your papers, I still don't have the schedules and statements that you need to prepare under penalty of perjury, so that I can really understand the changes. So for example, you just talked about surrendering a parcel of real property. That was not disclosed anywhere in the papers that I've reviewed today. So I'm a little bit struggling to fully understand your situation. Let me move on and ask you, what other changes have you occurred? So you've surrendered a parcel of real property. What else has occurred?
We had some companies that were part of our LLC, our Quartet Farms LLC, which we no longer have, and which were costing quite a bit of money monthly on board in Florida, and we no longer have those.
So what is that you said, that property? Was it personal property? Was it real property?
It wasn't. It's not a property that we own. I'm saying that they were boarded in Florida.
What was boarded?
The ponies.
You had ponies boarded in Florida, and you no longer own those ponies?
One of them was sold, and one of them is leased out for the year.
Okay,
That's yeah.
All right. I'm not going to be able to consider your emergency motion today until I receive your schedules and statements with full disclosures about what has happened in this case. I think what I will do is I'll hear briefly from Ms. Giaimo, and then I'm inclined to give you a short continuance until after the schedules and statements have been prepared and filed, so that I can review in writing your situation and I can have a better understanding as to what has changed between the dismissal of the prior case and the filing of this case. Let me ask you this question. Your papers indicated you were looking for counsel. Your case was filed nearly a month ago.
I have to pause this. I'm not the only one with allergies and probably going through a midlife crisis with having to clear my throat. Just saying. Let's continue.
On May 22nd. So, where are you with respect to obtaining counsel?
I have spoken with 21 different bankruptcy firms and attorneys. A lot of them are busy and unable to take the case. I have found one who is willing to.
21 firms. Now, if that doesn't tell you something, I don't know what does, and you only found one. 21 firms that don't want to take your case. That means you're SOL.
Take the case. However, because we ended up having to file pro se at the last minute, my understanding is that the post-petition, that the retainer fee post-petition has to be paid by a third party. So we are in the process of finding a third party to fund the retainer, and then the attorney has told me he would be happy to step in at that point, but that it has to be funded by a third party.
What is the name of the attorney you intend to hire?
Garaman Yusufov.
Okay. And when do you anticipate hiring Mr. Yusufov?
Just as soon as I can find the third party money.
So you don't have that lined up yet?
I am, it was not something I was anticipating having to do. So I'm reaching out to friends and hopefully we'll have something set this weekend so that he could come on board early next week. And I know the amended schedules are due on the 26th, and that the 341 meeting is on the 30th.
And so do you intend to retain Mr. Yusufov to attend to complete your schedules due on the 26th?
I would like to. If that timing doesn't work out, then I am committed to this. We are committed to this.
All right. As I indicated, I'm inclined to give a short continuance of this matter and impose a temporary stay under Section 105 because the 30-day period of your bank from the filing of your case is looming, which means that the automatic stay under 362 is about to expire. And I will say that on this record, I do not have clear and convincing evidence that there has been a change of circumstances. But let me turn to Ms. Giamo and hear from her briefly, Ms. Giamo, since you know pretty much what I'm going to do here. Thank you.
Thank you, Your Honor. Yes, thank you. Well, the first thing I want to point out is that, Your Honor said that you don't have the schedules and statements, but we do. We actually do have schedules and statements that were filed at docket 9 in the case, and that's a large part of the U.S. trustee's objection is the fact that there's huge misrepresentations in there. This is not
and you were correct. I'm sorry. Let me interrupt and just say there are scheduled statements. They are, in the debtor's terms, skeletal, which is essentially non-existent. So, and my apologies, but for the record, I will concede something was filed.
Thank you. And actually, I would definitely disagree with their claim that this was a skeletal petition. As Your Honor knows, many debtors file a petition, but they don't file schedules and statements, and they end up asking for an extension of time to file them. That's not what happened here. Mr. and Mrs. Owens, what they chose to do was file schedules and statements that were false. And that's just another indicator of their bad faith, and that they would choose to file schedules and statements knowing that they were signing them under penalty of perjury and knowing that they contained false statements. They should not have filed anything. Or if at the very least, they could have left everything blank, but they didn't. So I just want to point that out. That's a very key thing. And the other thing is, Your Honor, my understanding is that the court's decision has to be made before the 22nd. Or once the stay terminates, that's it. So I don't know when Your Honor wants to reset this hearing for, but I would argue that you have sufficient grounds before you right now to deny this motion because, as Your Honor pointed out, there is no clear and convincing evidence. There's no evidence at all in this case that there's been a change of circumstances. There were no change of circumstances that were listed in the motion, and there were none that were listed in the reply after I specifically pointed out in our objection that they needed to show that. There is no change in circumstance. And they will not be able to show that unless there's going to be more misrepresentation and there's going to be more inconsistencies between the various sworn statements they make. And I just don't think that these debtors should have another opportunity to make more false representations under oath to this court. I think the time is now to say what I have on the record is sufficient to show that the case was filed in bad faith. First, because there's a presumption of bad faith, because there's no change in circumstance. And second, because of all the reasons the U.S. trustee outlined in her objection, which is that there's a lot of evidence here of misrepresentations, egregious conduct. I want to address one minor last thing. Well, it's not minor. In their reply to the state's trustee's objection, the debtors claim that they never received notice of the initial debtor interview. And I'm going to take issue with that. And I'm going to say to Your Honor that we have a paralegal who mailed the notice of the initial debtor interview to the address listed on the docket sheet. That paralegal would be prepared to come in and testify under oath that he mailed out that notice. I find it extremely odd that Mr. and Mrs. Owens claim they did not receive that notice, but yet they were able to receive my objection to their stay extension, which was also sent by first-class mail. There was no email address on the record, so as Your Honor knows, we were required to serve these pro se debtors by first-class mail. That was the only method that we were allowed to send them service of the notice of the IDI. the initial debtor interview. And they completely ignored it. They didn't show up. That messes up the schedules of people in my office. And I think that by allowing this case to continue and giving these debtors an opportunity, even a short one, to try to file new schedules that might have, again, more misrepresentations, all we're doing is postponing the inevitable and allowing these debtors to continue abusing the system. And that's what this is. Thank you, Your Honor.
Okay, can we tell that Jennifer is not happy that she's done with this case? The problem is, it's just the beginning.
Great, thank you, Ms. Jamo, and I appreciate the position of the U.S. trustee, and I certainly have no issue with the mailing of the IDI to the debtors, and I don't understand why they assert they haven't received it, since under the mailbox rule, the presumption is that they did in fact receive that. I do not have sufficient information. I do know the debtor's motion for extension of time to file or amend the schedules did indicate that they understood that they were skeletal. I mean, I do think that there are certain discrepancies that need to be explained if they can be. But on this record today, I'm not prepared to lift the stay, given that this is the debtor's primary residence and time is short, and they filed under, it sounds like, some dire circumstances. So I will exercise my discretion to impose a stay under Section 105 for the temporary period for the court to determine whether a further stay is appropriate under the circumstances. I hope I have articulated to Ms. Naylor and Mr. Owens the court's concerns, and that on this record it does not appear that there has been a sufficient change of circumstances. But I will wait to see what the schedules and statements indicate, and I would ask again that the parties follow the rules when they file the papers. I know Ms. Naylor's papers complained that the creditor's objection, which has been withdrawn, was not timely filed because it was several hours late. And if she's going to make the complaint that others should follow the rules, I would remind her that she needs to follow the rules as well. So with that, let me turn to Ms. Hall and get a continued hearing date. And I'm looking for something shortly after June 26th and probably after June 30th, which is the 341 date.
Yes, Judge, we can set that for Wednesday, July 1st at 2 p.m.
All right, Wednesday, July 1st at 2 p.m. Ms. Jarmo, will you be traveling? Do you need to appear by video? Oh, you're on mute, ma'am.
I apologize, Your Honor. No, I will be home from my vacation by then.
All right, thank you. So with respect to the IDI, has that been reset, and will it be reset after? I mean, I think you need the papers in order to proceed.
Yes, Your Honor. So I left the office. I was left town on I believe Friday. So I have not been in communication. I don't have my work computer. I will have to reach out when I get back on Monday, and I will talk to the bankruptcy analyst and the paralegal who handle the scheduling of the IDI. But yes, obviously it will need to be rescheduled, and those documents will have to be given to the U.S. trustee before the 341 meeting. So actually, I do want to point out that if we do have, and I'm fine with Your Honor having the hearing go forward before the 341 meeting, but we will in all likelihood need to continue the 341 meeting because we need sufficient time for the analyst and the paralegal to reschedule the initial debtor interview, and then I will need time to be able to review with the documents before they come in for the meeting of creditors. So, like I said, I'm fine with the July 1st date to have this matter continued, and we can always do the 341 meeting after that.
Well, I'll let your office, of course, handle it. That's your office's prerogative, and you handle those. That's not a court matter. It's a matter through your office. I was just going to say it's unusual for the court to have granted an extension to file schedules to the 26th, given the 341 is on June 30th. I typically require those papers at least a week before the 341, and so I do see that this is a bit of a time crunch where those papers are due on Friday and the 341 is on Tuesday. So I appreciate your office's need to have a quick turnaround. So Ms. Naylor and Mr. Owens, I'm going to direct that you email those documents to Ms. Jaimo's office, as well as filing with the court's records, so that she will have them as soon as possible.
And which documents specifically are you talking about?
The documents that Ms. Jaimo has requested and the amended papers you're planning on filing.
The amended schedules, then?
Correct.
Okay. All right. Your Honor, may I say one more thing?
Just a moment. I have a question from the court. What is that?
This is really, really important, guys. Listen closely.
I'm guessing the court to ask about GoFundMe.
Ma'am, you are appearing by Zoom, as is Ms. Jaimo and others, and apparently there was a query to the court deputy through the chat system requesting the court to ask you about information where you have set up a GoFundMe site. Did you wish to address that?
Your Honor, I imagine this has to do with the smear campaign, which has been going on against our family for the last 3 years. A GoFundMe was set up on behalf of my husband by friends, and that was set up in December of 2024, and it was set up at that time in an effort to try to help us prevent the bankruptcy situation.
Your Honor, may I, if I can just intervene here real quick? I think what the issue is that there was a GoFundMe set up in the name of Mr. and Mrs. Owens, and I think there was over $100,000 generated, and that was never disclosed in the Chapter 13 or in this case. That's what the issue is. And that was something that I was going to delve into in the 341 meeting.
Okay. All right, thank you. Let's go ahead and wrap up this meeting, this hearing. Did you confirm dates and times?
Yes, I did, Judge.
We apologize.
Yeah, that's July 1st at 2 p.m.
So July 1st at 2 p.m. we'll resume this hearing. The court will impose a temporary stay or extend the Section 362 to stay via Section 105 temporarily until the conclusion of that hearing, when the court can consider in a more fulsome manner the schedules of statements that are forthcoming, the amended schedule of statements, and any other papers. And again, I've directed Ms. Naylor and Mr. Owens to email to Ms. Jaimo any papers that they file with the court, and also the papers for the IDI. And with that, I believe everything is concluded at this time. Is there anything further? Ms. Jaimo, I see your hand.
Yes, Your Honor. I just want to clarify, are you allowing the debtors to refile more pleadings in support of their motion after filing the amended schedules? And if so, I would ask that I would be given an opportunity to reply.
I actually have not asked for that.
Okay. But I prefer that, Your Honor. I think that the schedules should speak for themselves. So.
I agree. We have a motion, we have a response, and we have a reply, and that's all the court needs. Okay.
Very good.
All right. Any other questions or concerns, Ms. Naylor or Mr. Owens?
Yes, I have. So the 341 was scheduled for the 30th. Where does that stand?
It's still scheduled on that date and time.
On the 30th. Okay. And the continuance is July 1st. Okay. And the other thing is, I wanted to sincerely apologize with regard to the IDI. We did not get any notification in the mail about that, and I have gone back because I get daily notifications from the U.S. Postal Service with photographs of every piece of mail that I'm getting that day, and I have gone back and looked at the mail that was delivered, and what was in there for every day since we filed on May 22nd, and there was nothing that came to us with regard to an IDI or anything like that. So I have looked because I thought, did I miss it, or and it was not on the docket. And in fact, I had called.
It doesn't belong on the docket, and the court would have nothing about it. Let me just ask Ms. Jaimo to email whatever it is she's requesting directly to you, Ms. Naylor and Mr. Owens, and we'll move on. This hearing is concluded. Thank you.
Okay, so that one was the very first Chapter 11 bankruptcy. That was about a month ago. So the next one is going to be about 16 minutes long. And this was the one on July
In case 2605.
July 7th. So that's the one that they were talking about. Again, if you want to hear this straight through, go to Schnitzel Ninja. I'm actually going to put her link in my comments. She did awesome work on this. So if you don't want to hear my commentary and my interruptions and you want to hear it straight through, go to her page. So here we go.
144, Elizabeth Naylor and Ronald Owens.
I'll take the appearances in the Naylor and Owens matter. Ms. Chan? Did Ms. Chan just leave?
Yes.
Is Ms. Jaimo on the line? I wonder if Ms. Chan is supposed to be covering.
We're going to forward this a little bit because Jennifer didn't realize that they were even going to go through with this. So
this is the time set for the court to consider the status
okay,
of
here
this
we go.
Chapter 11 case. You've been before the court recently, and so I likely could have continued this matter to the next hearing had it been on my radar at our last hearing that because you will be back here, I think, next week. Ms. Hall, when's our next hearing?
August 6th.
Oh, it's in a while, so August 6th. So maybe not. Probably needed to go forward today. So you probably listened to the last hearing, which was a similar type hearing where the court covers what has happened in a case, what brought the case into bankruptcy, what are the reasons why we're here, and then figure out a plan for moving the matter forward. You've been before this court, so I'm aware of the status with respect to the stay, with respect to the pending motion to dismiss this case. That motion is coming on for hearing on August 6th. As we discussed at the last hearing, the court is taking care of the noticing out to your creditors on the master mailing list. And so, but there are some things that we can talk about today with respect to the pendency of your case. So first, let me ask you whether there have been any developments or changes of which you would like to make the court aware?
No, not that I can think of.
Okay.
No, so we were just before you last week, so nothing has really changed since then.
Okay. So the court had provided a deadline at the next hearing of, I believe it was
This Friday?
This Friday, the 10th, correct, to provide certain documentation and information to Ms. Jaimo and the United States Trustee's Office. How are you coming with that deadline?
We're coming very well with that deadline. We tried to send a huge file yesterday, which the server rejected twice because it was so big. But her office contacted me in an email that I got just on the way over here saying that they had instructions for how we could. They said they received it, but they were unable to actually open it. And so they have instructions on how we can redo it. So we'll do that right after this hearing.
Okay, very good. And if you had an extra copy, you could probably drop it off today. They're in the same building.
It is huge. I mean, we're giving her all of the bank statements, everything.
Okay.
You know, it's.
We'll get an electronic file is definitely better in that situation.
Yeah, and I think she wanted everything in PDF.
Perfect. Okay. Well, I'm glad to hear that that's coming well, and you believe that the deadline will be complied with. There are in a Chapter 11 case. I know you're looking to dismiss this case, but there are certain requirements with respect to fees that are paid to the U.S. Trustee's Office and reports that have to be filed. Have you discussed those with Ms. Jaimo?
I haven't. We paid the first installment.
I think that's your filing fee. There's also, so that's a fee that's due to the court.
Right.
And then there are other fees based upon the payments you make during your case, and then a percentage of that, or it's not really a percentage, but an amount allocated to that is then payable to the United States Trustee's Office. And has Ms. Jaimo discussed with you?
I haven't had that conversation. No.
Okay. Well, that's something that needs to be done as well. These are paid on a quarterly basis as well as monthly reports. So you have to file monthly reports with the court. Your case was filed I don't know if your report is quite yet due, but you probably have a report due on July 22nd is what I'm guessing. Here, just a moment.
The case was filed May 22nd, so that would be like 60 days.
Okay. It's let's see. All right. So as I see Ms. Giamo's on the line, ma'am, would you like to make an appearance?
Yes, Your Honor, I apologize. Jennifer Giano for the U.S. trustee. I realized this was a status conference. I wasn't sure if it was going forward. Apparently it is. I apologize for my tardiness, and I'm here now.
Okay, thank you, Ms. Giamo. I discussed with Ms. Naylor a moment ago that they're doing well in terms of gathering the documentation, which is due to your office on or before July 10th, and have received some instructions from your office with respect to how to break those electronic files down into, I think, more digestible bytes or whatever it is that can make those papers be transmitted. So I was glad to hear that. I was just discussing with Ms. Naylor that there are, in Chapter 11 cases, quarterly fees and monthly operating reports, and she might want to discuss that further with you offline. There was a partial report could have been due on June 21st, and then the first full monthly report is due on July 21st. So Ms. Giamo can discuss with you what that means and what those dates are. All right, so as I said at this time, like the case that was called before you, it's an opportunity to discuss with the court what brought you into bankruptcy. So I guess I don't necessarily have a good sense of that, even though you've been before the court previously. So what was it that precipitated the filing of this case?
Your Honor, we had a loss, a drop in income, and we had unexpected expenses, and we tried to stretch things out as long as we possibly could. This was not something that we wanted to do, but it really became untenable.
And you have a mortgage on your home?
Yes, we do.
Okay, and as I recall, that property was facing potential foreclosure?
Yes, and there's some confusion with regard to that. There is a foreclosure auction that I received an email as to what the date was going to be for the foreclosure auction. However, we have sent some correspondence to the law firm representing the mortgage holder, as well as to the servicer itself, and we have gotten notice that they are reviewing our communication. We have found some things that we think are violations that ought to be addressed, and we've been told that I think we got a letter dated July 2nd in the portal saying that they would get back to us within 30 days. So we are trying to pursue with the law firm. We're trying to get answers is what we're trying to get, and to see what we can do to move forward on that.
Well, I believe we discussed it at an earlier hearing. The court does have a mortgage modification program within the court, but you must take affirmative steps to be in that program. So if you want to avail yourself of it, you will have to file the appropriate papers. The mortgage company can participate, or they can also ask to be removed. But generally the way it works is there is a particular packet of papers. You file a paper, the court orders the mortgage.
Okay, sorry for that interruption, guys. If you heard my phone ring, this is why we're recording off of my new phone that I'm still trying to figure out. So my apologies. Okay, here we go. Back to the status conference hearing, and I do have to tell you that we kind of started ass backwards. But that's okay, because the little ones, I don't think we need to listen to those. But I just kind of want you to get the the drift of how this is going. And the grand finale, like I said, is Jennifer. When she gets in there, she is relentless. Okay, so here we go.
But if you're interested in exploring that, I would do it sooner rather than later.
Yes.
You can ask about that at the counter downstairs at the Self-Help Center. So that's something that I would suggest. In addition to that, should the foreclosure sale go forward, under Arizona state law, those sales, despite what you might think are irregularities or issues, if the sale goes forward, the sale is final. So generally under Arizona statutory law, and I can't give you legal advice, but I can tell you generally the way it works is that you would have to obtain essentially an order stopping the sale the night before the sale, if that is what you're inclined to do. Okay. So just wanted to lay that out there a little bit.
Thank you.
Was there any other litigation or creditor dispute pending before this case was filed?
No.
Okay, so you're not a plaintiff or defendant in any type of action?
No.
Okay, or your husband, Mr. Owens?
There was Chase, which had our a credit card that is included in the filing. Chase had said that they were going to file something, and then they dropped it once we filed for bankruptcy.
So they had sued you on the balance of that?
They had filed a notice of that, and then they dropped it.
Okay, and that was the only litigation?
That's the only thing that's the only thing.
Okay. Was there potential litigation that you could bring? Claims against others?
In connection with the bankruptcy, or
in your dealings, what were the personal circumstances that brought you into bankruptcy, and what was happening in your world personally and financially?
Well, I would think that we'd like to pursue what the violations might be with regard to the mortgage, but we don't have anything at this point. Yeah, there's nothing that I can think of.
All right. At this time, for this Chapter 11 hearing, I would typically set a deadline for filing a plan and disclosure statement. However, I know that you are interested in having the case dismissed, so I'm not going to do that at this time. What I will likely do is continue this hearing to that August 6th hearing we have on the motion to dismiss. Is there anything else you want to tell me now before I turn to Ms. Jayamal?
Not that I can think of, no.
All right, thank you.
So I just want to chime in here. The reason that they wanted this dismissed was so they wouldn't have to show documents.
I'll return to you in a moment. So Ms. Jayamal?
Thank you, Your Honor. The only thing that I would ask that the court convey to the debtors is that, first of all, they both absolutely need to appear telephonically at the initial debtor interview. They have received an email notice of when that's going to be held. It just never showed up in the last one. So I would ask that be done. They also both need to appear and testify telephonically at the 341 meeting. And then the last thing is, yes, I am in communication with Ms. Owens about getting documents. I know Your Honor had ordered them to provide an accounting of the GoFundMe funds, and that's what I was expecting was an itemized accounting. From what I can tell, I'm not getting that. What I'm getting is sort of a document dump of bank statements, and that's fine. I will go through the bank statements myself, but then I need to make sure I have all of the bank statements. So I'm going to ask that the debtors provide me copies with all of the bank statements of all the accounts into which the GoFundMe funds were deposited and from which the GoFundMe funds were dispersed for the entire period starting from when the GoFundMe campaign began.
All right. Ms. Taylor, do you have any questions or concerns about the request?
No, I think that is more than reasonable. Yes, I can. That is included in the file that we have sent to her. But I think that there is a way that I can clarify it for her, so that, and I can maybe point her more in the direction of instead of having to look at each and every one of these things. I think I can clarify that, and I will do so in an email this afternoon.
Okay, very good. Thank you. For my information, because I'm not sure exactly how it works on those GoFundMe accounts, I'm assuming there's a statement, much like a bank statement, that shows incoming amounts and potentially who they came in from, and then shows amounts withdrawn and where they went, i.e., to a particular bank account. Is that accurate?
Correct, and it's very, very clear. It's a very clear paper trail where it came in, how much it came in, what day it came in, and where it went.
Okay, and that documentation is part of the large file that you're trying to send to Ms.
Yes.
Jamo. Okay.
Yes.
All right. Very good. Thank you for the clarification, Ms. Naylor. Ms. Jamo, anything further, ma'am?
Nothing further, Your Honor. Thank you. And again, I apologize for my tardiness.
All right. Thank you. Glad to have you here. Let me ask if there's anyone on the line who wishes to be heard. This is the time set for the court to consider the status of this pending Chapter 11 case. All right, hearing none, let me turn back to Ms. Naylor and Mr. Owens. Is there anything further to hear from you?
No, Your Honor.
All right.
No.
All right, well, let's just confirm the continued hearing date and time then, which is August 6th. At what time, Ms. Hall?
At 2:30 p.m.
At 2:30 p.m. And again, I would note that yesterday the $600 installment for the next filing fee was due. That was due on July 6th. Ms. Taylor, did you make that payment?
Yes, I did, and I have a receipt for it with me.
Okay, very good. Thank you. And then the next one is due on July 31st. Okay. All right.
Do I need to give the receipt or?
No, it'll appear on the court's
okay, yeah.
on the court's docket. So
Yeah,
I appreciate
that
you have that. Okay. Is there anything further then, ma'am?
No.
All right, then let's go ahead and adjourn and conclude this hearing. We'll see you on August 6th. Good luck.
All right, thank you so much.
Okay, so that ended that one. And I just want to go back.
In the case 20.
Let me see here. There was a July 1st hearing. That one is about 30 minutes long. And that was the continued emergency hearing. So let's get into that one. And we will listen to that. And then there's one more. The next one's only about 7 minutes long after this one. And then it's the grand 2-hour finale. Now, the grand finale with Jennifer, we won't do today, but I promise I'm going to upload it today and we will get it on tomorrow. But I did want to get everybody up to speed, just kind of on the what's going on here. So here we go. And again, check out Schnitzel Ninja if you don't want commentary and you want to hear it straight through.
6051.
In a Chapter 11 case, motions to dismiss must be noticed out to the master mailing list. I believe it's a 21-day notice. It's unlike a Chapter 13 where a debtor has the right to dismiss their case at any time. Chapter 11 doesn't work like that. So I did want to, at the first instance, Ms. Naylor and Mr. Owens, tell you that the court has taken no action on your motion to dismiss because you have not noticed that out, I don't believe, to the bar, or I'm sorry, to your creditors, nor have you asked for a hearing or undertaken any other procedures that would allow the court to take action on your motion to dismiss. So from the court's perspective,
and I gotta say that this judge isn't taking any nonsense either. I think she knows what's going on.
That's where we are procedurally. I understand that the debtors no longer wish to be in this bankruptcy case. The U.S. trustee has asked that any dismissal be with prejudice and has a bar to filing for the next year. Often in these circumstances, the parties come to an agreement. And I guess that is my first question after that long introduction is, have the parties come to an agreement?
Yes, my understanding is that we have.
Okay, Ms. Jama, do you want to tell me about that?
Yes, Your Honor. So I spoke with Ms. Owens, and then I did call the case in the 341 at the time of the 341 meeting, and we have it on the record that both Mr. and Mrs. Owens, both debtors, agree that the case will be dismissed provided that they are barred from refiling in any bankruptcy court for a period of 1 year. I have sent, just today, I sent to the debtors a proposed stipulated order of dismissal And then I was going to ask Your Honor at this hearing if we could set the matter and have the debtors notice out the dismissal motion, and then hopefully if nobody responds, we can vacate the hearing and upload the stipulated order of dismissal.
All right, from a procedural perspective, that makes sense to court. The question I have, though, is at the last hearing, I heard a lot of information about ponies and GoFundMe accounts and other potentially non-disclosed assets, which leads the court to believe that there could potentially be non-exempt assets that could be recovered should this case be converted to a Chapter 7, and a Chapter 7 trustee had the opportunity to investigate and to potentially recover and liquidate those assets for the benefit of creditors. And similarly, if there has been a fraud upon the court or otherwise, whether the debtors could be denied a discharge, and that might be something that a Chapter 7 trustee would look into. And I didn't see that that wasn't addressed in any of the parties' papers, and I don't know if there's been a conversation. Ms. Jamo, I don't know if you've had an opportunity to undertake that analysis, but it seems to the court that it would be remiss to not at least explore whether it makes sense in this case to not just dismiss the Chapter 11, but to consider whether it should be converted to Chapter 7, where a Chapter 7 trustee can administer whatever assets might exist and potentially pursue fraudulent conveyances and transfers. And I guess what concerned me was if we had this large sum of money within the last year for the GoFundMe account, that seems to be an asset that could be potentially recovered for the benefit of creditors. If it was paid to one particular creditor, say the mortgage company, that money should be recovered for the benefit of all the other creditors. And so these are the thoughts that came to me as I read the parties' papers. I don't know if anyone would like to address that.
I can address that, but if the debtors want to speak first, I'll wait my turn.
No, go ahead and address it if you'd like to.
Okay. So, yes, Your Honor, we absolutely thought of those things, and I appreciate Your Honor bringing them up because those are very crucial issues. In fact, my initial analysis of this case, I saw that the writing on the wall was going to be likely a motion to convert or dismiss and likely conversion. However, regarding some of the assets, I know that there was discussion about some horses. The debtors have a daughter, Laura Owens, who had previously filed a Chapter 7 case, and that case has since been dismissed, but I spoke at length with the attorney, Terry Dave, the attorney for the Chapter 7 trustee in that case, and my understanding was that there was not any feeling that there were really going to be collectible assets that were worthwhile to pursue for the benefit of creditors. And I know that it was the same companies that are owned by the debtors and that were disclosed in this case. Now, the GoFundMe, no, that would have required further investigation on my part, and it was something I was going to pursue in the Section 341 meeting. I think that this outcome is probably the best right now. There's no other creditors, not even the banks have come in and said anything, which I was a little bit surprised about. But I do think that if the case is dismissed, provided that they do not file for a year, then these financial matters will sort themselves out. So it's the U.S. trustee's position that this is a good outcome, provided that there be a bar to refiling. If the court is not inclined to grant it, then absolutely we would take up the 341 again, and I would say that in all likelihood, we would be back before you, Your Honor, asking for a conversion.
All right, thank you, Ms. Jamo. And I guess the way to maybe tease that out a little bit is to go ahead and get that motion to dismiss noticed out to the creditors and others. I guess what concerned me was just looking at the docket, there was the motion to extend the automatic stay, which was opposed by the secured creditor. And then curiously, the secured creditor withdrew that opposition, which suggests to me that perhaps funds were accumulated and paid to the secured creditor, which is why they withdrew their objection. And if so, then that would be a classic preferential transfer that would be an asset to be recovered for the benefit of all other creditors. And so I think that's something we should get some better understanding on before the next hearing. So that's what the court's thinking. And so again, I'm inclined to give you an opportunity to notice out that motion, because I'm not going to grant it here today. Your creditors need to have the opportunity to understand that is what you're looking for. But what do you want to tell me, Ms. Naylor?
I was going to tell you that no funds have been transferred, and with regard to the GoFundMe, which I'm sure you were notified by the online smear campaign that has gone against us.
Let me just interrupt you to say that the court only reviews what is filed with the court. So I know you referenced an online smear campaign before. I really have no idea what you're talking about. All I have is what has been filed on the docket and what people tell me in open court. I do not independently go out, and it would be unethical for this judge.
Okay, so they're trying to say that the online smear campaign is because of the shit that her daughter, or their daughter, Laura, pulled with The Bachelor, Mike Maroncini, and Greg Gillespie, and all the other victims. So Justice for Clayton, which is a website, and they're on Reddit and YouTube and things like that. It was for Clayton Eckert. And they're trying to say that the JFC crew is the reason that their bankruptcies aren't going through. So that's that.
For any judge to go out and do background research on people and learn about them. So just so you know, that's the way the court will operate.
I'm not suggesting that. I know that the smear campaign people have said online that they have sent information to your office. So I don't know whether you've received it or not. And I know that they also sent it to the U.S. Trustee's office. But with regard to the GoFundMe, as I mentioned before, it was started in 2024, and all of the funds from that were
listen closely about the GoFundMe funds, because like I said, this is so important. They are trying to not have to give that information up. They want to keep that like under lock and key. Nobody can find it. Stuff it under your mattress. So that's what they're trying to do.
Exhausted by, with the exception of maybe, I don't know, a couple $100 or something like that, we're all completely exhausted by the time that we filed Chapter 13 last August. That money was used, and in fact, the GoFundMe was started in part to try to prevent this bankruptcy and the Chapter 13 that we'd had to file last August, to try to get the funds. And at that point, some of the funds from the GoFundMe were used to pay mortgage at that point, like I say, before we filed the Chapter 13. So it was all virtually exhausted by, I would venture to say, by May of 2025. So that's why we didn't mention it in the Chapter 13 filing, because it didn't exist. It had been used.
Well, transfers that are made shortly before the bankruptcy filing do have to be disclosed. That it's problematic if you did not disclose the use of those funds. I'm going to order and direct that you provide the records concerning that particular issue to Ms. Jaimo, so that she has an understanding as to the financial circumstances immediately preceding your prior case and this case, so that her office, and the court has a full understanding of the circumstances before the case is dismissed. because the court does need to make a determination whether best interest of your creditors would require conversion rather than dismissal. But at this moment, the court will not make any such determination. And again, the only information I have is that which is filed with the court and that it appears on the court docket. I don't believe I have any communications on the court docket from other parties, only the filings that I've seen from you and the U.S. Trustee's Office and the creditor. I believe that's all I've seen on the docket. Okay? Okay. Do you have any questions about the information I'm directing you to turn over to Ms. Giamo?
If you could just outline it again so that I can take a note on it.
I'm really asking for a full accounting of the GoFundMe account, the monies that were received and the monies that were spent and how they were spent. And so, the whole typical information, what did you get? When did you get it? What did you do with it? Where are your receipts?
Okay.
Okay. The who, what, when, where, why, and how. Okay.
Okay, but again, that was all prior to the Chapter 13, that if we'd had those funds, we wouldn't have needed to file Chapter 13 or Chapter 11.
Okay. Well, I hear what you're saying. Some transfers can be recovered despite the passage of time. This case was filed on May 22nd of 2026, and it could be that if there were funds that were transferred in a particular period, they would be of interest to the U.S. Trustee's Office. Okay? And let me ask Ms. Giamo whether there are other information. I know that I had directed you to email to Ms. Giamo the information required for the initial debtor interview as well as the 341, and I don't know if that's occurred. I believe that should happen before this case is dismissed. I think we should have a fulsome understanding of your financial circumstances. So I'm going to order and direct that you provide that information to Ms. Giamo's office. Everything that you're supposed to be providing, you need to provide. So whatever that office is asked for, I'm ordering and directing you to cooperate and to provide that to her.
Your Honor, we were unable to do that. I had presumed that we would be able to get counsel to help us. This was never my intention to file pro se, and I'm very aware of the fact that Chapter 11 is a very exhaustive chapter to go into as a pro se litigant.
And here come the excuses. Brace yourself, guys. She just needs to stop talking, because the more that Jan talks, the deeper the hole gets.
And that was not our intent. Our intent was to be able to get counsel, and we have been unable to obtain counsel.
Well, you know your financial circumstances best, and so you should be able to reconstruct that information and gather those records to provide it to Ms. Giamo.
But, Your Honor, I'm unable to without adequate counsel. If I had been able to do that on my own, we would have continued this on our own.
Right, but you filed this case. You filed a Chapter 11 bankruptcy case. You have not yet paid the full filing fee. And once you're under the jurisdiction of this court, you have to abide by the United States Bankruptcy Code and its rules and requirements. And I'll tell you, one of the most important things about the Bankruptcy Code is it requires absolute transparency. And that's the concern of the court, is that the schedules and statements here compared to the prior schedule statements seem to indicate a lack of transparency. And so as a participant in the system, you have certain obligations, and I'm directing you to fulfill those obligations. And when we return for the next hearing, Ms. Giamo can give me an update and let me know what she's been able to learn. And it could be that a dismissal is still the recommendation, and it will be the course of action. But it's not appropriate to file bankruptcy and park in bankruptcy and obtain the protections of bankruptcy and yet not fulfill the obligations. And so again, that is your obligation. You filed this case. You undertook these duties and responsibilities, and now I'm directing you to cooperate. All right, Ms. Giamo, anything you need to add?
I just want for clarification, Your Honor.
I'm going to pause. Be very careful when you're dealing with the government. That long pause in there That was Jan and Ron not saying a word. That wasn't me. That was them. So, got to be careful when you're screwing with the federal government because FAFO, right?
So the noticing of the hearing on the motion to dismiss, which we'll discuss what happens in the interim, is that something that the court is going to notice out, or are the debtors required to do that?
The debtor should be noticing it as a Chapter 11 case. Let me ask the court deputy if there's any provision for the Chapter 11. Generally, in Chapter 11, those debtors undertake the noticing. Do we do that?
They do, Judge, but we can if we need to.
Okay.
Yeah.
Take a look at master mailing. Let's see how big case. We're going to take a look at the master mailing list. Just a moment. So the court will do that for you. The court will send out, it's highly unusual in a Chapter 11 situation. Generally, the debtor or debtor's counsel sends out the notice of hearing. The court will do that. The court has set the hearing date for August 6th at 2:30 p.m. The court will send out the notice for creditors and parties in interest who might wish to attend. Within that notice, we'll also be advising folks if and when they'd like to file an objection when that's due. And this will give Ms. Jaimo an opportunity to receive the papers that the court has directed you to give to her in connection with the IDI and the 341. I'm not going to hold those deadlines in advance. You were previously ordered to provide them. You haven't provided them. Where the court sits, you're currently in contempt, ma'am.
Oh, I understand. Okay.
Okay. Any other questions or concerns, Ms. Naylor or Mr. Owens?
None for me.
Okay, thank you. Ms. Jaimo, anything further? I'm sorry, Ms. Naylor, did you have a question?
Well, the foreclosure date has been set for July the 28th, and I have filed some objections with the lender to the mortgage lender.
This is also an important part because so August 6th, if that is their next actual court hearing, the foreclosure is supposed to happen before that. And I think that is the reason that they decided to do the bankruptcy, to try to prevent to have the house sold. But there's an issue with that.
To see what can, and I would like to hire an attorney to handle the foreclosure. So I'm just wondering about how those dates coincide. My hope was to retain outside legal counsel to resolve the debts with the mortgage lender and also the unsecured creditors outside of Chapter 11. So that was what I had hoped to do before July 28th. So with this date being set of August the 6th, I'm a little unclear about the overlapping.
I don't really understand your question. I mean, the court has set a hearing on August 6th, and you said you have a foreclosure on July 28th. So yes. But I don't understand what your question is. You stated facts, but what is the question?
The question is, if the hearing is set on August the 6th, how does that impact foreclosure on the 28th? Because there's no, we had asked if the stay could be continued.
Now, let's not forget that the house that they're talking about, they also have a quote-unquote dependent daughter who's 36 now, who doesn't work. But they're losing their house.
I see what you're asking is if the court would be inclined to extend the stay that's temporarily in place.
Correct.
Is that what you're asking? Okay.
Correct.
Just
to allow us to sort through all of this.
Ms. Jarmo, do you have an opinion?
Yes, Your Honor. The U.S. trustee objects to the extension of the stay. I mean, this is precisely one of the reasons that the U.S. trustee considered the case to be filed in bad faith and an abuse of the system. I believe that the debtors have not paid their mortgage to the tune of $191,000 of arrearages. And while they're seeking the benefit of the stay, they haven't complied with the obligations of the bankruptcy court to justify getting the benefit of the stay.
Did you hear that, guys? 191,000 in arrearages. That means that's what's owed back. That's not what is completely owed on the house. That is just what would be needed in order to get them up to date. 191,000. Some people's houses don't even cost half of that much. Just saying.
All right. Do you wish to respond, Ms. Naylor or Mr. Owens?
Well, we have filed letters with the mortgage holder. We believe that there are very, very serious issues that the mortgage holder needs to address with regard to this, and we've filed lengthy letters with them and are waiting to hear back. We've been told that we will get a response, so we're kind of waiting to hear back as to what will happen there.
Okay. Well, there's two things in play here. Number one, if you have issues with a mortgage holder and you are making claims or assertions to them or about them, that's completely separate and distinct. That's not occurring in this court. So there's really nothing that this court can do to help you with those transactions with your mortgage lender. And I think you're communicating directly with them, so I believe you understand that.
I'm not sure we are communicating directly with them. I mean, it's been very, very difficult to get to the people that we really need to get to. That's been one of the issues. There seem to be a lot of folks at play here. We get told one thing by people that we have spoken to on the phone with the mortgage servicer, and we get the very next day we get a letter in the mail saying you have options, we can modify things. So it's been very much up in the air. We get a bill that says that the monthly mortgage is due, and then we get another thing in the mail saying that all of the arrears need to be dealt with. So we really have been trying very, very hard for a long time to get this resolved and to get something in place so that we can move our lives forward. And as I say, we have uncovered things that we feel are violations that really need to be addressed before a foreclosure could take place.
To the extent that you have claims or issues with the mortgage holder or the servicer, and I know sometimes it's difficult to understand, who to speak with, in particular when servicing is transferred, it can be a bit of a challenge. But it sounds like those are issues that you have to take up directly with them. There's nothing pending before this court. This court can only rule on and consider the matters that are directly in front of it by motion or otherwise. So I can't really speak to that situation. And to the extent you want to assert claims, those are generally the types of claims that are asserted in federal court, outside bankruptcy, at federal district court, or at state court, or injunctions are obtained in state court before foreclosure. So I can't really speak to your situation with your mortgage servicer. I think you'll have to continue to deal with that and find a way to connect with the appropriate individuals or to assert those claims in a proper forum. This is generally not that forum in bankruptcy court, so I'll answer you that. With respect to the pendency of the automatic stay, I have to agree with Ms. Jamo that at this time, there's no basis upon which this court should continue to extend the automatic stay. by operation of law, should have expired on or about June 22nd or June 23rd. The court
You
did
know that
take
their
the
heart is
extraordinary
pounding right
step
now.
of looking at Bankruptcy Code Section 105 and to temporarily extend that stay so that you could perfect the papers that you've already filed with the court and participate in your 341 and participate with the initial debtor interview. And unfortunately, those things have not occurred. The papers have not been amended. The U.S. trustee has not received information for the IDI, the initial debtor interview, or the 341. And so this court can no longer continue to extend the automatic stay. So to the extent that your motion to dismiss asks this court to hold deadlines in advance, the court declines to do so. And again, that motion is not technically before the court anyway. But at this time, during this hearing, which was set on a status hearing for your motion to extend the stay, the court's going to deny that requested relief. I cannot find on this record that there has been clear and convincing evidence, which is the standard, but I cannot find that there's clear and convincing evidence of a change in circumstances between the dismissal of the Chapter 13 case and the filing of the Chapter 11 case for the reasons that we discussed at the prior hearing. So that is the order of the court. I will put that in the minute entry, which will be signed and circulated, and the court will also undertake the noticing of the motion to dismiss. And if there's, Ms. Jamo, so what I guess what the court would be noticing out is the motion as filed, and then if the parties want to work out the terms of their written stipulation, then that can be presented at the hearing. Sometimes that itself is noticed out, but it doesn't sound like you're ready to have that noticed out. Is that fair?
That's fair. Yes.
Okay.
Yes, I think that the best thing to do at this point is just to have the motion to dismiss noticed out, see what kind of response, if any, what responses are filed. And then also in the meantime, I can better evaluate what our position should be in light of the documents I'll be receiving and the testimony we'll be getting at the 341.
Okay. All right, fair enough. Well, I think that concludes all business on the court's docket here today. We've set a hearing on the motion to dismiss on Thursday, August 6th at 2:30 p.m., which the court will notice out. And that notice will be given to all creditors listed on the debtor's master mailing list, and we'll take that issue up then. With that, I'll ask one more time if there's any questions or concerns. Ms. Jamo?
Yes, just one thing, Your Honor. I just want to clarify for the record the deadline by which the debtors need to provide our office with the, number one, the accounting of all the GoFundMe funds, and two, all of the documents that they already are on notice of being required to produce as part of the initial debtor interview. May I suggest that the deadline be set no later than Friday, July 10th, because that gives me sufficient opportunity to review the documents before the 341 meeting.
So that is, I was just going to look at a calendar. That is a week from this Friday, which seems like it should be a sufficient amount of time. So Ms. Naylor, I'm inclined to embrace Ms. Jamo's suggestion of Friday, July 10th to provide the documentation. Okay.
Okay.
All right. So it's hereby ordered that no later than Friday, July 10, the required documentation for the 341, the initial debtor interview, and the GoFundMe accounting shall be provided to Ms. Jamo's office. We previously discussed that I would like those documents emailed in electronic form to her office, and that will be the order this time. Anything further from the parties?
No.
All right.
Nothing from the U.S. trustee. Thank you, Your Honor.
All right. Thank you. We're adjourned. Good luck.
Schnitzel Ninja.
Okay, so again, we kind of went a little ass backwards here. This is the meeting of the creditors, which was held on June 30th. Very quick, so we'll just run through this. And then I think as far as the Chapter 11, we pretty much got a really good rundown. Like I said before the grand finale, it was 2.5 hours with our Queen Jennifer. So um, it's leading up to it, guys. We're almost there. Here we go.